Good morning and welcome back to the Kelso Report for Tuesday, May 29th. I'm your host, Clark Kelso. Hope you had a very good long weekend. We begin with a prisoner rights case in the Ninth Circuit today, and Wilhelm v. Rotman. The Ninth Circuit reviewed a pro se prisoner rights case involving allegations that two doctors violated the plaintiff's Eighth Amendment right to medical care. One of the doctors failed properly to diagnose a hernia requiring surgical treatment. The other doctor noted the hernia and recommended surgery, but no surgical reference was made because the reference was denied by the prison's utilization management system because of the doctor's sloppy documentation. And the doctor did not follow up and clear up the documentation until the prisoner several times more requested assistance over a good year or so. Indeed, the doctor actually had canceled a second referral without explanation. Now, the patient ultimately received the surgery, which did resolve the problem, but there was a long delay. The Ninth Circuit held that the complaint against the first doctor was insufficient because it alleged mere negligent failure to diagnose, and negligence isn't good enough for the Eighth Amendment. However, the complaint against the second doctor did allege deliberate indifference in implementing a treatment the doctor had himself recommended. Although the court recognized that the complaint was pretty close to the line, the Ninth Circuit held that it was sufficient to pass the preliminary screening phase of a pro se prisoner rights case, and so it ordered the complaint to be served on the second doctor. The case then will proceed forward. Presumably there'll be a motion to dismiss will be the next thing that the court will take a look at. Apologize. Second case is also a prisoner rights case. This one coming to us from Nevada. In this case, Snow v. McDaniel, a 69-year-old death row inmate, claimed the Nevada Department of Corrections was deliberately indifferent to his medical need for surgery to replace both of his hips, which have degenerated so severely that he has excruciating pain and can barely walk. The Ninth Circuit held that jury questions were presented on deliberate indifference when the evidence showed that the department's doctors ignored the advice of two outside orthopedic surgeons for 3 years who recommended hip replacement surgery, and instead the inside doctor simply treated the inmate for his pain. According to the Ninth Circuit, while a medication-only course of treatment may have been medically acceptable for a certain period of time, the question remains whether it was medically unacceptable and subjectively reckless to ignore a long-term recommendation for 3 years, or to ignore emergency and urgent requests for more than 2 years. The Ninth Circuit held these were fact questions for a jury, and so it reversed the district court's decision granting the state's motion for summary judgment. It did not help the state's case that the warden was quoted as telling medical staff, quote, "If one of these death row inmates gets deathly ill, don't knock yourself out to save their life. There's plenty more to take their place," close quote. Well, now we turn to California Court of Appeal cases. The first involving an evidence decision and the internal affairs and personnel privilege. The Fourth District in Rezac v. People faced the question of whether statements of witnesses to the crime with which the defendant is charged are immune from discovery because the statements were obtained as the result of an internal affairs investigation and placed in an officer's personnel file. The answer, according to the Fourth District, is a qualified no, they are not immune. In particular, a defendant may obtain the statements on a showing of good cause made in a motion brought pursuant to Evidence Code sections 1043 and 1045. Now, the issue of access to statements that are in an officer's personnel files usually arises in the context of so-called pitchus motions, dealing with evidence of complaints against that officer involving third persons. For example, complaints about excessive use of force. In Rezak, the court recognized that the defendant's interest to information in the officer's personnel files was of even greater weight than usual, since the evidence directly related to the charged crime. Accordingly, the court held that disclosure of such documentation or information is not forbidden, unless disclosure is specifically precluded by the narrow exceptions provided for in subdivisions B or C of Evidence Code Section 1045. Finally, we have a case involving a revocation of public pension programs, an issue that sure is sure to get a lot of attention. The City of San Diego established by city resolution an incumbent president program that purported to establish a special pension benefit for the president of local firefighters unions. However, the city charter provided that pension benefits must be created by city ordinance. And the 4th District therefore held in San Diego City Firefighters versus Board of Administration that the program was not properly established and therefore did not create any contractual rights. So, when the IRS issued a compliance statement declaring the program to be in violation of Section 401A of the Internal Revenue Code, the city could retroactively revoke the program without breaching any contractual or constitutional rights. In addition, the city established by MOU and city ordinance an annual leave conversion program. But the MOU contained a savings clause in case its provisions were contrary to provisions of the Internal Revenue Code. And again, the IRS had issued a compliance statement declaring that the leave conversion program was contrary to Section 401A. And, according to the court, that declaration triggered the savings clause, invalidating that portion of the MOU. Accordingly, again, the city could retroactively revoke the program without breaching any obligations under the MOU. It's quite clear the court's holdings here don't go against the general rule that pension benefits, once vested, are contractual rights and they may not be revoked. What the court did in both cases here was decide that there actually was not a contractual benefit that ever came into existence to begin with. And so the city could revoke that portion of the program. Now, as I say, this case will get a lot of attention by pension reformers around the state. I think people are going to be looking to see whether this type of analysis provides some mechanism for pension reform where you won't be able to have successful challenges based on contract or constitutional privileges. And that's it for today's Kelso Report. Have a great day in the law.